Everybody. I think we'll wait just a couple more minutes. We have about 20 people that are RSVP'd for this, and then we'll go ahead and get started. Go ahead and get started. Good morning. My name is Jennifer Hiramoto. I'm Deputy Director for the City of Glendale and Community Development. On behalf of the City of Glendale, I would like to welcome you to today's webinar on a proposed hospitality worker workplace protection ordinance. It's hard to say 3 times fast, let alone once. This ordinance was originally brought to us by Unite Here Local 11, a union representing hospitality workers in Glendale. This ordinance includes provisions to address the fair discharge and recall of employees, worker retention and rehiring, and safety provisions for our hospitality workers. Our City Council asked to convene you, our stakeholders, and gather your feedback as part of the outreach process. Before we get started, I'd like to go over a few housekeeping rules for today's session. Our presenter will be taking your questions and comments at the end of the presentation, and you may submit those questions via the chat box function. We will get to as many of those as possible during the question and answer portion of the webinar, and we'll also be sure to get your feedback to inform our policymakers before they make their final decisions when this goes back to City Council on June 9th. With that, allow me to introduce today's presenter, Jillian Van Meiden, Chief Assistant Attorney for the City of Glendale, as she walks us through the proposed ordinance. Jillian, take it away.
Thank you very much, Jen, and I want to thank everyone for participating. I will be presenting to you the PowerPoint that was presented to our City Council on April 14th, and based on that PowerPoint, we did receive direction unanimously from the City Council to reach out to you all as stakeholders to gather information vis-a-vis the surveys that have been sent out and to respond to your questions. We anticipate, as Jen said, bringing all this information back to the City Council for their consideration on June 9th. So we do encourage your participation, not just here in this context, but also through written or other dialogue with the members of this panel, including Jen and myself, Ani Pagosian and Juan Gonzalez, who are our support and research team and set up this webinar for us. So we're very grateful for your participation. And I'm going to launch right into that by sharing my screen with you. So let me just do that. One moment. Hopefully you can all see that. Jen, perhaps you can nod to confirm. Thank you very much. So this is the presentation that was provided to the City Council on April 14th, and I'm going to walk through it, starting with some background. In March of this year, we received, and that's the recently part, a request from Unite Here Local 11 to enact urgency legislation to protect hospitality workers in response to this COVID-19 crisis. And a summary of the contents of that proposal pertain principally to fair discharge and recall provisions, a preference for rehiring, ways to retain hospitality workers in the event there is a change in control, which I'll talk more about as we go through this presentation, a requirement for public hygiene training and hand washing, a collective bargaining agreement supersession, and that means just how does the ordinance interact with existing collective bargaining agreements, and also dealing with instances of potential retaliation and how it will be enforced. In looking at the proposed ordinance, what we learned is that many of the provisions actually source from other existing ordinances. So for example, the fair discharge and recall provision is not in Santa Monica's existing ordinance that has protections for hospitality workers. It actually sources from the City of Philadelphia and was adopted in 2019. The rehire preference also comes from the City of Philadelphia. Hospitality worker retention pertaining to change in control comes from the City of Los Angeles 2006 ordinance. public hygiene training and the collective bargaining agreement supersession are from the city of Santa Monica, as is are the retaliation enforcement provisions. The hand washing and public hygiene provisions are new. And that is a summary of the cities from which this ordinance that was presented to us were cobbled together. If anyone is interested, you can go online on the city's website and look at the agenda packet that was presented to the City Council on April 14th. The ordinances from these cities are included in that as background in that agenda packet. So let's launch into this ordinance. The first chapter principally provides definitions for the various aspects of this, and hopefully you all have a copy of the draft ordinance. I believe that was sent out to all the participant stakeholders, and that you'll be asking questions at the end of the presentation. So as I've indicated, the City of Philadelphia's 2019 Municipal Code adopted a provision for wrongful discharge for their parking employment individuals, their employees. And so that was recontext for hospitality workers to protect them from discharge for anything other than just cause or bona fide economic reasons. The ordinance that was presented to us did not include a definition of just cause, although the City of Philadelphia does have that definition. We did include that definition of just cause in our ordinance. And what it is, it's on page 3 of the draft ordinance, item M. Just cause discharge means a discharge of a hospitality worker for failure to satisfactorily perform job duties or for misconduct that is demonstrably and materially harmful to a hospitality employer's legitimate business interests. It is important for us to have a solid basis, definitional basis on which enforcement of the ordinance would be undertaken. So what is this preference for rehiring of discharged employees? So that's the recall component of the fair discharge and recall of workers. There are definitions for rehiring of what are qualified employees that have not been discharged for just cause, and it would apply retroactively to the adoption of the ordinance. Workers are qualified if they're held the same or similar position at the site prior to the discharge, or they could undertake the work with the same training. And so that rehire preference would be based on the similarity between new and old position and whether or not they had seniority. Such an offer would have to be accepted by a qualified worker within 10 days after, or to accept or reject a rehire offer as specified in the ordinance. So let's talk about the retention provisions. We're in Chapter 102. It protects workers from discharge due to what's called change in control. And I think it's important to understand what that means. So a change in control is defined in the ordinance, and what it means is a change in control is any sale, assignment, transfer, contribution, or other disposition of all or substantially all of the assets used in the operation of a hospitality facility, or a discrete portion of the hospitality facility that continues in operation as a hospitality facility, or it's any sale, assignment, transfer, contribution, or other disposition of a controlling interest, including a consolidation, merger, or reorganization of a hospitality, by a hospitality employer of any person who controls a hospitality employer, or a series of events, including this purchase, sale, lease, or termination that causes the identity of the hospitality employer at a hospitality facility to change. For purposes of this chapter, change in control shall be defined to have occurred on the date of execution of the document effectuating such a change in control. So what happens if there is one of these defined changes in control? Well, there are requirements for the operators to post notice. for the prior employee to provide a list of eligible workers to the new employer, for the new employer to maintain and hire from that list for 90 days, except where that worker is discharged for just cause, or where legitimately there are fewer workers required because there is a smaller operation, for example. And that retention would be based, of course, on whether or not there is a collective bargaining agreement and how the terms of that agreement would apply on seniority or experience. Hospital retention, worker retention, continued the provisions. So new employment under the new, with a new employer would be under the terms and conditions of that new employer. And again, the discharge could only be for just cause reasons. The notice requires written job offer contain the job specifications. Within 90 days of the hire, the new employer would be required to perform a performance evaluation. And an offer of continuing employment by that new employer would be based on that evaluation being satisfactory. So let's talk a little bit about the next provision, and this is the public hygiene training requirement. The provisions in the ordinance proposed by Unite Here 11 are quite extensive. The direction that we received from the City Council on the 14th is to implement those components of the training that pertain to personal safety. And I will get to that. So, and there is a training component that would be required as part of that. What we would not be implementing based on council direction are the provisions for additional time for sanitation, cleaning, etc. That is not direction that we received. So, however, in terms of the public hygiene training requirement, what would be implemented for purposes of safety is a training by a qualified third party that the city would establish this training program and certification. The trainer would be required to have specified experience that would be accessible to, for example, immigrant low-wage workers, and would be required to use specified training techniques. In the ordinance, it does say live training would be required. That is something that we would need to revisit if such training techniques could not be employed in that way in this world of social distancing. Right now, it's required to be 6 hours. That, again, would need to be revisited in terms of how it could be most effectively implemented under the circumstances that we're in. So what is not being implemented would be the best practices and techniques vis-a-vis COVID-19 or infestations of insects or vermin. However, the council did direct us to implement training vis-a-vis this ordinance for issues related to criminality, human trafficking, domestic violence, threatening conduct, and worker right and responsibilities. So with respect to the implementation of this public hygiene training requirement, that compliance certificate by the employee must be obtained, and an employer cannot continue to employ that employee for more than 120 days without such training certificate. Hosts, and now we're talking about short-term rental cleaning, would also be required to have certified employees. And this ordinance would be, as proposed, effective 90 days from the effective date of the ordinance. Again, given the timeframes for putting together a training program of this nature and the need to budget and create a staff to implement it, the 90 days may not be a time frame within which this could occur. That is as currently proposed, and we will be returning to the City Council with additional information on the city's ability, given our own budget and the changing circumstances that we're in, how we'll be able to implement this and what is realistic. So the 90-day draft date may not hold. Again, in the proposed ordinance, there were measures to facilitate hand washing, etc. Those were not chosen by the City Council in its current direction to be implemented in this iteration of the ordinance. Moving towards the end of the ordinance provisions, there's a provision entitled Supersession by bona fide collective bargaining agreements. Essentially, this provision interacts with the fair discharge and recall of worker provisions that are in chapters 1.01 and 02, which could be waived if there is a collective bargaining agreement, if that waiver is not unilaterally imposed. And so we would appreciate the feedback from both the Unite Here representatives and the workers, as well as the hospitality employees on the interaction between this provision and collective bargaining agreements. Moving towards the end, Chapter 107, retaliatory action prohibited. This does set up a rebuttable presumption that actions taken after exercising the provisions protecting employers by this ordinance are presumed to be retaliatory. However, that presumption is rebuttable. And of course, now with the definition of just cause, it would be a fact-finding investigation to determine whether or not the retaliatory move, whether or not the discharge action was in fact retaliatory. At this moment, the enforcement provisions include civil remedies, and that would be injunctive relief and damages to enforce this proposed ordinance, and it would allow for a private right of enforcement. So these were the potential next steps that we presented to the City Council on April 14th. And we've been undertaking both of these things. And that's why we are here with you in this webinar. We're looking forward to your questions. Juan Gonzalez and the rest of our team have been contacting other cities around the country to look at the implementation of their existing ordinances and how they are, and to what extent they are adopting these new proposed provisions. And we will be summarizing that information and providing that to the City Council. And we are looking now at the market in Glendale and the effect of the COVID crisis on our economy here in Glendale, particularly with respect to the hospitality industry. And we're here reaching out to you. And I do believe that is we've been undertaking what we've been directed to do. So, and part of that as well is to evaluate the policy impacts fiscally and legally on the city. And it's important that we get this information now, given that we are in the middle of our budget adoption process. So I believe that that is the end of my presentation. And Jen, I'm going to kick it back over to you to see if we have any questions.
Great, thank you, Jillian. At this point, I don't see any questions that have popped up, but now would be the time if you have specific questions about the impact that this would have, or how you would, any concerns you have about implementation, any other questions that you may have, feel free to chime in.
And Jen, I might add that for anyone who is interested, probably the best way to reach me or Jen is our first initial with our last name that you can see on the screen at glendaleca.gov. So please feel free, if this format is not a format that you're either comfortable with or desire to ask questions within, to reach out to us via email. Again, the first initial and last name, so that would be G Van Meiden at glendaleca.gov, or J Hiramoto at glendaleca.gov. So we sincerely appreciate your time. So Jen, I'll turn it back over to you.
Great. So it looks like there's a few questions that have popped up, Jillian. So the first one, I'll just go ahead and read it and kick it over to you. It is my understanding that the California Hotels and Lodging Association has reviewed the proposed ordinance and will be forwarding their comments. Can you confirm if they have received their comments? Jillian?
I have not, so I would ask either Juan or Ani or Sandra whether or not, well, first of all, I would want to know to whom those comments were sent, and if they were sent, we'd like to track those down, because definitely we want to receive those comments.
Great. I'm not sure if we know the answer to this, but one of the questions is, does Union 11 provide the list of companies who can provide the training?
They have not. However, we will be reaching out to them, as well as other communities that do undertake this training to ensure that we have a list, and we may need to go through, depending on the value of the contract, either a very short RFP process, but if there's only a one or two, we may be able to look at dispensing with an RFP process. It just depends. So yes, we will be asking them if they, what companies they've worked with, as well as asking other cities.
Great. Also a question regarding who is paying for the training scheme. I know we have done some research on how to implement that. Jillian or Juan, if you wanted to chime in.
Juan has been researching this aspect of it, and by contacting other cities. Juan, if you want to chime in on what you have learned so far, at least on a preliminary basis.
Thank you, Jillian. On a preliminary basis, a couple of the cities have contracted out with consultants to do the training. That's been my research so far.
Okay. So another question, has the staff had an opportunity to review the ordinances that were just passed in the city of LA, county of LA, and city of Long Beach? I assume so, but wanted to check. Thanks for your work on this. Jillian?
Yes, thank you very much. Danielle posed that question. We are collecting those ordinances as we speak and digesting those. We will be, again, as I mentioned earlier, summarizing all of the recently passed legislation as well as existing legislation. City of LA, Santa Monica County, Long Beach, everyone, this is information our council will want to know. So the answer to that is yes, we're looking at it, and we will be summarizing that information.
Excellent. One is regarding the pandemic. So since this ordinance is in response to COVID-19 pandemic, is the ordinance going to expire once the pandemic is over?
At this point in time, we don't have a sunset date on that. No. But that is a question that we would certainly, it's a policy issue. It's less of a legal issue as it is a policy issue. So if the council may decide to impose a sunset date, that is a question for them.
Okay. Are there any other questions at this time?
I might want to add, in case, hopefully I didn't miss this while I was reading the questions. To the extent you have not taken the survey or you are unaware of the survey, please let us know. That's very useful for us, for both employees and employers, to get a sense of the feelings, the concerns, the questions and issues pertaining to this proposed ordinance.
Thank you, Jillian, on that. That survey can actually be located, and we'll go ahead and provide that link again, but it's glendaleca.gov /HWWP. And we definitely encourage you to respond to that. Another question has come up. So in regards to safety training requirements, brands spend significant resources on ensuring that our colleagues are well protected. It is important to us that our colleagues feel supported. Instead of the city appointing trainers and the hotels having to spend additional resources on duplicate training, it is my recommendation that the hotels be able to present training that they already conduct with their colleagues, and if sufficient, consider the hotels to be in compliance.
Yeah, that's a really good question. And part of what I have read so far, well, and you'll see this in the ordinance, is that this training should work in concert with the training that's already provided by the brands. And to the extent, and to eliminate overlaps to the extent that those trainings do not fulfill the purpose of the ordinance. This is where this training would fill those gaps. But the other aspect of this is the certification. So the brand training alone would not qualify for the certification that's required under the ordinance. But certainly there would be a high level of coordination between the brands and the training required vis-a-vis the ordinance.
Great, and it looks like there's a follow-up point on that where the commenter is saying that additionally, the same goes for public hygiene training, that they contract with nationally reputable companies that can provide them with training and certification.
Yes, and that would be handled separately to the extent there is an overlap with the public safety component of it, the worker safety component of it, vis-a-vis criminality and human trafficking, etc. I see that there's another question, but I think it pertains more to employment law, and this is a little bit more specific about whether or not an employee can leave or quit without providing the 2 weeks notice. That would be not the subject of this particular ordinance. So I would refer that person to their employment contract and to an employment representative if they are an employee, for example. Yeah.
Great. Another question came up regarding the draft ordinance. As written, there was a potential for criminal liability against employer violators of the ordinance. Is that still the case?
Right now, we have offered that to the city council as an option, but I think well, I think it's just my personal opinion, but this is certainly a policy decision that the likely direction the council will take is civil enforcement only. And it seems to us that most cities are pursuing or have adopted or will be implementing civil enforcement only.
Okay. Any other questions? Feel free to write them in. Otherwise, we will go ahead and take these questions and comments and incorporate them within the staff report and recommendations to the City Council when we return on June 9th. And as mentioned, please go ahead and take the survey. We'll make sure that all of you receive that link at the conclusion of this of the webinar. Thank you all for participating, and thank you, Jillian. Today's webinar was recorded and will be posted online at our website. So if there's other folks in the community that you think would appreciate this information, you can feel free and share it with them if they were unable to participate. You can also, yes.
I saw one more question in the chat, I'm sorry. And it had to do with whether or not there's a sunset date to the ordinance like the Families First Act. The answer to that question is no, not at this time. No sunset date.
Okay. Great, thank you, Jillian. So you can also provide feedback directly to our City Council during the June 9th council meeting where we will report back to them. So staff will send out a reminder email with the call-in number once it's available. And you can also send in letters as well. So with that, that concludes our presentation. Thank you for your participation. We are here collecting feedback to get your concerns. And again, we appreciate your time on this matter.
Thank you, Jen. Thank you, team. And thank you to the participants.